Supreme Court today, in a 4:1 majority, have upheld Section 6A of the Citizenship Act, added as a clause during the signing of the Assam Accord. This is a relief for migrants who entered Assam before 1966 and between 1966 and 1971, while the CGI observed that mere presence of different ethnic groups does not infringe Article 29 that protects culture of citizens. The dissenting verdict from Justice Pardiwala stated that Section 6A was valid at the time of its inception in 1985, but not anymore. The contention was mainly by indigenous groups who were asking why Assam has been singled out in this clause. The Supreme Court said that the further process of deportation will be monitored by them and has also upheld the power of centre to identify and deport illegal migrants. We'll talk about this with our guest. Joining us on the show is Mr. A.K. Singh, Advocate of Supreme Court, Mr. Ashwini Dubey, Advocate on record, joining us on the show as well. Mr. Kaustubh Deka, Professor of Dibrugarh University, also joins us on the show. Mayur Bora, Political Analyst, with us on the program as well. Thank you everyone for being a part of this conversation. Ashwini, I'll begin with you. Well, this is an important verdict. It's an important relief. It's an important accord. But again, it's also imperative to understand that this is not an easy decision. It's got overlays. It has interpretations that may resonate or create a ripple effect for other citizenship aspirants as well.
Yes, Vineet bhai. Since today's judgment is basically 3-4 issues, larger issues deals with. One, that whether it is violative to Article 14, because as you rightly said that if you see the amendment which were carried forward subsequently, and that is the large scale protests were going on. So this judgment would be having whether any impact on that or not. But here the Supreme Court by 4-1 majority judgment has categorically dealt with that the grant of citizenship to migrants from Bangladesh to Assam was within the legislative competence of Parliament under Article 11. Article 11 says that Parliament to regulate the right of citizenship by law. So far as this subsequent amendment 2019 is concerned, that would also be covered by this, because Parliament has power to regulate it. And so far as the reason was being cited for being violative of Article 14 of the Constitution, so this judgment will definitely show a path subsequently. To article whether the Section 6A of the Citizenship Act adopts unreasonable cutoff date, because there is a cutoff date, Vineet bhai. That was the 1st January 1966 and the March 25, 1971, which was fixed by the Assam Accord and which was also inculcated and found place in the Constitution of India under Article 20. Then the other question was that so far as the Article 29(1), whether the protection of interest of minorities. So Supreme Court by 4-1 have also dealt with this issue and says that this is not violative to Article 29, subclause 1 of the Constitution of India, and whether Section 6A of Citizenship Act can be regarded to be violative of Article 355, the duty of union to protect interest of states against external aggression, because there was external aggression. And as you rightly said, now it is within the domain of the government to detect, detain, deport to those who are violative to the Assam Accord, who are not within the competence of the cutoff date, which was fixed by tripartite agreement between the government, state governments, and central government, and those who were protesting there in the Assam, that these Bangladeshis who have come from Bangladesh and migrated, they have changed the demography, they have changed the cultural identity of the Assamese. So they would not be allowed to vote for 10 years. But yes, with large issues, number of issues, very, very contentious issues have been addressed by Honorable Supreme Court today. Over to you, Vineet bhai.
All right, important observations there. Mr. A.K. Singh, what has been your assessment of what the Supreme Court mandated today?
Besides the point validly raised and kept by my learned friend Ashwini ji, I want to say one more thing. See, the question was raised, why Assam? Why not the other states? Why not the West Bengal? Why not the Bihar? Why not even Delhi? There are so many states where even more than the Assamese illegal immigrants are residing. Even in the Bengal also. In the Bengal, it is stated around 57 lakhs of the immigrants are residing. In the Assam, around 39 or 40 lakhs immigrants are residing. In Bihar, around 26 lakhs illegal immigrants are residing. Right. So the question was validly raised in the Supreme Court, but in the verdict, the Supreme Court has stated the population versus the number of immigrants. The court has stated that in Assam, Assam has a less land than the West Bengal and the Bihar. So in context of the Assam, this legislation was the okay, and the Parliament has validly enacted the law, and the power of the Parliament and the constitutionality of the law both has been validated by this verdict.
All right, let me take a reaction from Mr. Kaustubh Deka as well, professor of Dibrugarh University. Mr. Deka, how do you look at this pronouncement? And of course, the Assam Accord is an important factor here for the Supreme Court to go by.
So, as you rightly say, we have to go back a bit into the history here. There is a cultural context as well as a political context here. And it is no doubt an important judgment, but in essence, it actually maintains the status quo of citizenship in Assam as it was. This challenge that came before court, it came from certain organizations and certain quarters which was not very happy and resentful of 1971 as a cutoff date, and which considered that it compromises with the indigenous interest of the indigenous communities of Assam. So therefore, that part of cultural insecurity, that Assam had additionally taken the burden of 20 years of citizens from across the border, whereas other states of India kind of, decided on a cutoff date of 1951. That was the bone of contention here, which was addressed by the Supreme Court, and this dispute has been settled in that manner, so to say. But there is a larger political context also here, which is very crucial for us to understand, that we have to read this judgment in consonance with other provisions like Constitutional Amendment Act, that is CAA, that was very hotly debated in the context of Assam, and the other exercise that involved a lot of dispute and debates regarding citizenship in Assam, that is the context of NRC. So Assam, as you might, all of us know, was in news, very much in news in last few years regarding these two provisions of CAA and NRC. So this particular judgment definitely has to be read in that context also. So therefore, how will it play out? What will be the dynamics of this judgment? That is something that has to be watched out for now. That is what I will say for the time being. And of course, the larger political ramifications, curiously enough, if you see the flow of history is so strange and curious, that the very groups that had been at loggerheads during Assam movements have found themselves on the same side of law. For example, all Assam Students Union and other groups like Minority Students Union, that political party that represents minorities, they are in fact on one side of the law when it comes to this judgment. So therefore, Assam is such complex, this has a complex political history, and we can see how political discourse is shifting from one side to another side. Okay, Vineet, so that's what I have to say.
Mr. Miyur Bora, what according to you would be the political implications of this particular judgment?
No, political implications, I don't think, if you see the history of Assam for the last 40 years, the issue of illegal immigrant or immigrant migration before independence has been going on for last more than, in fact, 100 years. And after independence, if you see, certain political parties have made the people who have migrated before independence and immigrated or infiltrated after independence, they have been made a vote bank by the Congress party earlier, because of which in 1979, as a spontaneous site of outburst to that the whole effect in which the indigenous people felt that they are threatened, their interests have been jeopardized, it is going to be extinguished. In that context, Assam agitation came up in the year 1979. And I am not particularly surprised about the verdict today from the Supreme Court, as it has maintained the status quo, what we have achieved after Assam Accord. All the people, all the indigenous people of Assam are not very happy with the 1971 as a cut-off date. Let us be very clear about that. But they have also understood, they have shown a tremendous amount of sacrifice by accepting that 1971 be the cutoff date because of an international event which is beyond the control of anyone in the country, that is India. Because the emergence of Bangladesh and the new country of Bangladesh has come in the year 1971. As you all know, the Bangladesh, that war has ended on that particular date, and the new country was created on December 16, 1971. Because of that particular event, Assamese people have sacrificed. They said that for 20 odd years, more than anyone else in the country, we have taken. But from now onwards, once we have accepted the date as 25th March 1971 in the year 1985 itself, that is more than 39 years ago, now it is incumbent, or it is expected, that all the political parties should work towards expelling, at least detecting and deporting those illegal migrants. But all the people, all political parties, you just name it, they have been doing only politics. The current political party, that is BJP, they, while coming to power before 2016 election, they said in their manifesto that Assam Accord would be our soul. It will be the soul, and we are going to detect. In fact, the then Prime Minister of the country, he came to the neighboring state of Assam, and he said that moment we come to power, everyone has to pack up and they have to go to Bangladesh. But all has turned out to be some sort of jumla, some sort of joke perpetrated on the people of Assam. Now the verdict has come from the Supreme Court. We have sacrificed to 20 years in comparison to other states of the country. Now I appeal to all the political parties. You are asking me about the political ramification. I will appeal to them very earnestly, not only as an Assamese but also as a proud Indian citizen, that enough politics you have done in the name of this particular issue. Now Supreme Court, the All Assam Students Union, Assam government, different organizations, may more or less they are on the same page. They said that 1971, except for Assam Public Works or the Sanmilita Mahasangha, who has filed that case in the Supreme Court, most of the organizations, albeit grudgingly and reluctantly, they have agreed about the date of 1971. So now it is incumbent on all political parties and non-political parties also to reduce the noise and start the working of detecting, deporting, and NRC you were mentioning about. Even in flawed NRC is flawed. We need to have lot of revision in certain areas of the state. But even in the flawed NRC, we have got a list of around 19 lakh people whose names are not there, but they are residing in the state of Assam. So if they are genuinely interested in detecting and deporting those people to Bangladesh, then I think they can start with this 19 lakh people. But I am afraid most of the political parties, they are busy, because you know this is the politics of primordiality. People do politics in the name of community, in the name of religion. We are looking at all those things very, very, what should I say, sadly, and it's a very sad development all throughout the world, and more so in the country in the last 10 years. So Assamese people have suffered enough. Now my appeal to all the people, try to do something, try to walk the talk after 39 years of signing of the Assam Accord, and which has been legally endorsed and ratified by Supreme Court today.
All right. Mr. Prashanta Rajguru, Editor-in-Chief of Prague Satellite Channel, also with us on the program. Mr. Rajguru, I hope you can hear me. Thank you for joining us. Well, of course, you've heard the previous panelists and, the complexities when it comes to Assam, and the overlays are so much that, there is no one party that can benefit from what the Supreme Court pronounced today. What is your take on this entire matter?
First of all, I fully agree with Mr. Mayur Bora that this is for the first time the Assam Accord has been ratified and have been given a constitutional and legal validity by the Apex Court and the constitutional bench. And that is a biggest achievement of all Assam Students Union, number one. Whether it is an achievement of Assamese people or people of Assam or not, that is another matter. But all Assam Students Union was sticking to Assam Accord, and they were sticking to 25th March 1971 as a cutoff year to detect the foreigners. And at the same time, all Assam Minority Students Union, who were on the other side, they were also sticking to the same cutoff date. So this is the win-win situation for both of them, and this is a very peculiar development. This is a very, very peculiar development that the agitationists and the people who are living on the other side, the non-agitationists who are against the agitation, they have also owned the game. Number two, the political implications of this particular judgment, which I am yet to go through between the lines and the entire copy. I have got only conclusions. This is a very interesting observation on the part of Apex Court. It said in the part D, B2, the cutoff date of 25th March 1971 is reasonable because Pakistani army launched Operation Searchlight to curb the Bangladeshi nationalist movement in East Pakistan on 26 March 1971. Migrants before the operation were considered migrants of Indian partition. That is very, very peculiar observation, because the migrants who have come before 1971, they have been considered as the migrants of partition. So this is a judgment. It is on record. And thirdly, the NRC, the process of NRC. Now the process of NRC is hanging. It has been kept, but practically in abeyance, because BJP, the Bharatiya Janata Party, they have a narrative that let the case be over, let us have the hearing, final hearing from the Apex Court, because the cut-off date may be go back to 1951. So let us wait for that. And now the BJP cannot propagate that narrative that 1951 will be a cut-off year one day, and then we will start the this NRC process. So Assam government, at the same time, they said that NRC have some flaws. Fine. We do admit that NRC may have some flaws, but Assam government again said that they are demanding at least 20% of random revision in the bordering areas of Assam and Bangladesh, and 10% of random revision in the other parts of the state. But the state government of Assam and NRC authority yet to file an affidavit on this issue in the Apex Court. So now it is clear that Assam government is free to file an affidavit. The NRC authority is free to file an affidavit seeking the revision of NRC. If there is any flaw at all, then this verdict will be the base for that. So this verdict, I am not very sure that whether the people of Assam all are very happy. I am not very sure. Some of them may be very unhappy. But if you take a pragmatic approach, then 1971, 25th March should be the cutoff year for deporting the foreigners, because that will be the most practical way to find out the foreigners. But in front of us, everyone have seen a large number of foreigners who have come after 1971 have been regularized, or there is a provision in the piece of law, namely Citizenship Amendment Act, that they will be regularized and they will be given citizenship, Indian citizenship, although they have migrated from erstwhile East Pakistan or now Bangladesh. So, in context of that, the 1971 cutoff year is the most valid, practical cutoff year, I believe.
Ashwini Dubey, for all those people who in fact do not make the cut, what happens to their legal recourse?
Vineet bhai, see, he has raised altogether a new point. It is a political issue. Very rightly, he said that if intention is not, I'll come to what you asked, but before that, intention is required, the bona fide intention to deport them. Now, today, during the hearing, Vineet bhai, Honorable Chief Justice of India asked to the state government and to the center to submit the details of those illegal migrants who are settled here. The Supreme Court of India has today said there is a feeling that an unlimited influx of illegal migrants from Bangladesh not only changes demographics but also poses a burden on resources meant for Indian citizens. And not only this, Vinit bhai, you have discussed number of times that there is a serious threat to the law and order. Yes, review petition can be filed, curative can be filed, and the other states, because this is a question with respect to the validity and constitutionality of Section 6A of the Citizenship Amendment Act, because this was only with respect to the state of Assam. So whether this is not the violation of Article 14, as A.K. Singh ji has rightly said, Vinit bhai, that the state of Bihar has also illegal migrants. Even Delhi, I and you live in Delhi. Delhi has also a lot of Bangladeshi refugees, illegal immigrants who are protected by the parliament in Shaheen Bagh and other places. We have seen the changes, the demographic changes, that is also needs to be looked into. But so far as 6A of the Citizenship Amendment Act was concerned, that was with respect to the Assam, because Assam is a neighboring state, because very conveniently those from Bangladesh migrate, come inside, and then the sleeper cells help them, and they get settled and mixed with the because of the almost close cultural identity and the bodily similarities. But the question is that how long the courts would protect. It is the duty of the central government, state governments to work collectively. The state of West Bengal is one of the serious threats, from where they immediately enter and settle all over the country. Mewat we have seen last year, Nu we have seen last year, and easily we find that those rickshaw pullers, sometimes the garbage cleaners, sometimes we see the car cleaners, they all Bangladeshi. In day they work, and in night they involved in the activities, the illegal activities. That has also to be looked into. Courts are there, but you see how long it took from 1971 till 2024. The accord was signed way back in 1985 or 84, and this is 2024. Now the question is being raised that those who entered in this country from 66 to 1971 would be given citizenship, and after that from 71 to 2024 they would be detected, detained, and then deported. So that process has to be streamlined, and there has to be method, there has to be check, and the agencies should work fast so that they should be deported and they should not enjoy our resources. That also finds place in Supreme Court judgment. So courts are there. Court has to look into the constitutionality of a matter. That court has to see that whether that is violated the constitution.
Ashwini, what about the agencies? How are they prepared to go through this litmus test?
Agencies, have we seen as of now the detention centers? No, Vinit bhai. We see that he's a Bangladeshi. Police always see that those working in South mates, they are having the fake identity card, but they don't take any action, because that is the parliament has to regulate it, and the state government cease to have any power or jurisdiction to send them directly back, because there has to be, they can detain, but ultimately they have to report to the central government, because the citizenship is a central issue. So that has to be streamlined, and there has to be a clear executive direction with this respect. Then if police can detain, can inquire, can investigate, these are the parameters. If they do not fulfill, they should go back.
All right. Well, we've run out of time, but I'd love to accommodate more thoughts and reactions from our panelists. But nevertheless, it's an important decision, riddled with complexities, but the ones that definitely will be put to test in the next few weeks.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.